Good afternoon. My name is Carolyn Cooper. I'm with the Bureau of Justice Assistance Criminal Courts Technical Assistance Project at American University, and I am the host for this session on managing capital cases. I want to introduce our panelists briefly. Phil Knox, who is with the Maricopa County Superior Court in Phoenix, and has had a number of assignments in various positions at the Maricopa County Court, and before that in Houston. And Phil is really the brainchild of this panel, because we at the Bureau of Justice Assistance Criminal Courts Technical Assistance Project worked with Maricopa County in helping them develop some strategies to manage the pending capital caseload, which when we got involved was 143 pending capital cases. But I think it was Phil's feeling that even one case can really dislocate a court system, and so it's really the strategies that we used both in Maricopa County, but you'll hear from Lubbock County and you'll hear from Los Angeles. They're all kind of common themes that are relevant, I think, to any type of case, any type of court. With Phil from Maricopa County is Judge Gary Donahoe, who has been on the Maricopa County Court for 21 years, has had a number of positions, and has received a number of distinguished awards from the Bar Association and other community groups in Arizona. At the time we became involved with Maricopa County, he was the presiding criminal judge who was really faced with making some tough management decisions on how to handle the caseload. And I think, as we heard from Justice Broderick this morning, there are a lot of innovations that courts can implement to try to make their case process more efficient. But what Maricopa County was facing was the interaction of a lot of other agencies, particularly the county attorney that was charging so many cases as death penalty cases. And I think the leadership that he exerted was really remarkable. And then we have David Slayton from Texas, another state that is known for a number of death penalty cases. David is the Director of Administration in Lubbock County and has had a number of positions in court administration. He's a graduate fellow from the Institute of Court Management, and as you know, has been very active in NACM. And David is going to talk also about, both from the court management perspective, some of the initiatives they have taken. And unfortunately, Jack Stoffagen, who was the manager or the director of the Regional Public Defender Office in Lubbock County, what's a regional area, who was going to be on the panel, is stuck because of the snow, and he wasn't able to get out of Lubbock. So David's also going to present some of the initiatives that the Public Defender Office has embarked on. And then we have Kathy O'Connell from Los Angeles, who's acting senior administrator for the Los Angeles Superior Court Litigation Support Administration Division, where she oversees the judicial courtroom services, court reporter services, audiovisual and appeal units. And she says Los Angeles County leads most of the nation in death sentences, but we hear there's some places that compete for that title. But anyway, we know that she handles a lot of death penalty cases. And she's going to talk about the importance of the court record and when a death penalty sentence is imposed, and all of the implications for the court administrator's office in terms of certifying the record. And by the way, she also works with court locations in over 20 sites. So she's got quite a challenge. So I'm going to turn this over to Phil now.
And thank you, Carolyn. And again, appreciation certainly from me and from Maricopa County to the Bureau of Justice Assistance, Criminal Courts Technical Assistance Project, and American University. So thank you again. It actually funded quite a bit of the travel and such for this presentation. And we are being filmed and recorded this afternoon, so and we will field questions from the audience here today throughout. So if you have a question at the time, we'll certainly go ahead and try to respond to that. But we'll probably have to repeat it at least for the sake of the recording. To give you a bit of background on Maricopa County, and the other presenters will also present some of this. And just as an overview, before you even get into this anymore, we have tried to logically have this in segments for you, and to have a presentation for you that first talks about a very large jurisdiction. You can see here on the slide, population of over 3.9 million, and that will likely go up with the 2010 census. But a court that size, and you see the number of judicial officers on the bench, we'll compare that to a jurisdiction with 270,000 that did something in Lubbock and western Texas that's very novel and gives smaller jurisdictions some ideas on how to respond to handling capital cases. And then in summary, or in conclusion, we'll have Kathy relate to the appellate process for these types of cases. So that's how this is segmented out. But again, Maricopa County in landmass size, 9,200 square miles, which is obviously very large. We only have 15 counties in the state, and the state's probably 8th or 9th largest geographically among our 50 states. You see the bench has 153 judicial officers, judges, and commissioners. And you see just below that a total of over 50 that are dedicated to the criminal case department alone. And as was mentioned, Judge Donahoe, at the time of much of this background and working through the case backlog with capital cases, was the presiding judge in the criminal department. So these judges and commissioners reporting to him. State statutes authorize death penalty with jury sentencing. The challenge that Maricopa County faced, you see that first number, capital cases in fiscal year 2008. And the state of Arizona, the fiscal year is July 1st to June 30th. The capital cases the following year, to give you some perspective, just 1 year later, rose to 136. You heard Carolyn mention that at some point, at this highest point, we had 143 capital cases in Maricopa County alone. That's just one county. And you see some of the challenges again below that: limited qualified defense attorneys and mitigation specialists. And the way we went through this presentation this morning at 10:15, Judge Donahoe and I he'll jump in at some point, and I'll ask for some background. This was his daily practice. He was actually on the bench with some of these cases. He was managing the other judges that we had. You'll see here at some point we had 15 or 16 judges managing capital cases. He was meeting with them regularly. So he'll offer some commentary on a lot of these things. You see the Ring case, Ring versus Arizona. Some of you remember this, went to the U.S. Supreme Court in 2002. It actually contributed to our backlog by a number of 30. What happened in that case, briefly, and I may actually turn to Judge Donahoe to help with this, but in 2002, the U.S. Supreme Court ruled 7-2 that juries and not judges should take into account the aggravating factors when sentencing persons in capital cases. Judge, do you want to? That's about it on that?
That's in a nutshell.
Yeah.
Well, what it resulted in was Arizona changed its statute to jury sentencing, and it had a big impact on how cases are processed, because under the old system, we do the guilt phase, and then because it was going to be a judge sentencing, it might be 12 to 18 months later that all the mitigation be done, and then you do the sentencing. Right now, we just do 3 phases, and they're all back to back. You do the liability, guilty, not guilty phase. You do the aggravation phase. If they find a capital aggravator plus first-degree murder during the liability phase, we go right to mitigation. So when the case goes to trial, all the mitigation has to be done and ready to go.
And you see again, as I show that this contributed, this Ring decision, and we listed all our Ring cases. There were 30 of those that came back to us in Arizona. And so we had to ultimately retry those again to some degree. And so those added to that backlog. So that helped with that spike number, but we still had to work through that number. like I said, in that decision, it was 7-2. There was only one dissenting opinion that was written by Judge Sandra Day O'Connor. And primarily, she focused her dissenting opinion in the Ring case on the fact that this would have a huge impact on the caseload and the workload in trial courts across the country, and ultimately, as you can probably think through, more workload and caseload problems for the appellate court as those cases went through them. The percent of first-degree murder cases treated as capital cases at 40%. You see that number. That actually came out of the American University BJA report when we surveyed the other 14 counties in the state of Arizona. So that was a 40% rate compared to, for example, Pima County, which is the next largest, which is Tucson, was closer to 10%. So you can see a lot of the problem surfaced through the filing decisions made by the local prosecutor for Maricopa County. And then the caseload standard notation there is we had, for case flow, we were to move these cases from death notice to conclusion of the case to 18 months. What you're going to hear later is that some of these cases in that backlog that we mentioned were at 3 and 4 years at that point, so they were well past that 18-year and a half. And then I wanted to give another perspective as to the total amount of work done by those 51 judges and commissioners. So you see there approximately 36,000 felonies were filed in Maricopa County of that. And on average, we would see another 35 or 36 death penalty cases filed, and those are included in that 36,000. Addressing the issues, the Arizona Supreme Court, there was a task force that was formed even earlier in 2007, and this Supreme Court administrative order directed that it was directed at Maricopa County, and pretty simply stated from the Supreme Court directed us to handle this matter. I mean, it was only a Maricopa problem. It wasn't a problem in the other 14 counties. So there wasn't a whole lot of direction there. It did establish a capital case oversight committee that regularly met. And at some point, once Judge Donahoe took over, that committee was already in place, but he then became a member as a presiding Maricopa judge. So, Judge, you might want to relate some of the parties that were in attendance and on the committee and some of the things that were going on during the committee.
All the stakeholders in these cases were on this committee. I was the criminal presiding judge. I was on it. They had prosecutors, defense lawyers, mitigation specialists. They had members of the public. And it was chaired by one of our Supreme Court justices. And it became very apparent to me that when I started in January of 2009, that all the players in this, it was a totally dysfunctional relationship. And nobody wanted to take responsibility for the backlog. Everybody was pointing their fingers mainly at the court. It was, in my terms, they were throwing the court under the bus and blaming us for the backlog. And when I started in January, I took a look at it. And to some extent, they were right. So we made some changes. And it's kind of like you better be careful about what you wish for, because when I announced these changes at the meeting in March, what we did was develop this plan, vetted it with our criminal bench, got everybody on the bench to buy in, and then I told this committee what we were going to do in March. And boy, these people went ballistic. They couldn't believe we were really going to take possession and control of these cases, and we'll talk about that a little bit later.
And then you see here the next bullet, Maricopa County Superior Court Administrative Order that was issued 9/3 of 09. That was signed by our then presiding judge, Barbara Mundell, and it was keying off of a lot of what came out of that committee. And then, too, we were also working to cure our own problem, even prior to the 07 Arizona Supreme Court order that was issued. But the Maricopa County Superior Court order, since it was issued by us to direct our work in the courts, it had much more specificity as to what we were supposed to be doing to fix the caseload problem. So just briefly, that Superior Court administrative order set forth that we were to set the last day at 18 months from the arraignment. A last day is a last day to go into to start a trial on these cases. That's the terminology we use. To set a firm trial date in capital cases, to have a final trial management conference date 30 days set before trial. I mean, these are things that likely you've heard if you've attended case flow through ICM, or if you listen to some of the experts in case flow management. These are the things that you typically will do to help fix your problems. Assign case to a capital case management judge. At the time, we had about 15 or 16, so we were going to narrow that and train them to handle these cases. So set up a cadre of specialist judges, for example, with the training that they needed, and order a resolution management conference 60 days or more before the final trial management conference. So those things were stated in the Superior Court order as to what we were supposed to be doing specifically. So all these things were going on. And then our court administrator, Marcus Rankensmeyer, and Judge Mundell in late 2008, 2009, engaged AU and BJA to come in. And so they agreed, and you can see the dates here. They were with us from March 2009 to September 2010. September 2010 is the date of the final report that was issued. So we just received that several months ago. And the consultants, there were 6 consultants, and then Carolyn and Joe Trotter were there as well. But of the team that was actually on the ground for several days to speak to judges, they actually went to the Capital Case Oversight Committee. The only real problem that we faced, that team faced, was getting in to talk to a representative of the county attorney's office. The county attorney, and for those of you who follow news, including Arizona news, between our county attorney and the sheriff, the courts didn't have very good relationships with either, or let's just say they didn't have good relationships with us. And so we, through some negotiation, were able to get at least 2 of the prosecutors on that team to be able to go talk to someone representative of their office, just to get some sense as to the charging of the notice and how they work their cases. And so we were able to at least do that through some detente with the county attorney's office. But there are also, other than the 3 prosecutors, there were 2 public defenders and a trial judge that were on that committee, or that team. You want to take some of this?
Yeah. This was the culture that I came into, and it's, at least as far as charging now, they have 60 days from arraignment essentially to file a notice of death. You can get a 30-day extension, but the notice of death has to be filed early on in these cases. So we were aware when a capital case became capital pretty quickly after the defendant was arraigned. Our state has a long list of statutory aggravators that make a case capital. We have 14, so that's another issue as to you can make almost any first-degree murder case capital case under Arizona's statutory aggravators. But our cases were assigned, we had these 130, 140 cases assigned to roughly 15 judges on the criminal bench. And the only qualification you had to have a capital case on your calendar was have been in the criminal department for a year. So the judges had all these capital cases, and the management was from good to not so good. Individual management, we had 15 different judges with 15 different styles, complete discretion on continuances. Some wouldn't even set trial dates. When I decided to implement this new system, that was one of the things I went through all the cases and made sure they had a firm trial date. Some of these cases, as Phil mentioned, were 36 months or older, and they were just continuing to roll, continuance after continuance. One of the issues in these cases, or in many of these cases, is mitigation. If you are familiar with capital cases, A large percentage of these cases, guilt really isn't an issue. And the defense attorneys recognize that. It's really about the sentence. And what they try to do, if you're not familiar with these mitigation specialists, is go back from the day you're born to the current and research your background, get all your medical records, employment records, whatever. And they say that takes about 18 months. Well, we were trying to manage that through these mitigation master conferences. We would appoint another judge, not the trial judge, who would meet with the mitigation master, defense lawyers, and the defendant, and make sure and see what we could do to facilitate the mitigation in order to keep it on track. We ran into some victims' rights issues. We have victims' rights constitutional provisions. Statute says that a victim is entitled to be present in court whenever the defendant is. And we ran into some issues there. So after about 6 months, 8 months of this mitigation master program, that I thought was doing really well, we terminated it because we were concerned about the victims' rights issues.
Let me take a second here. As we're moving to this new screen, you saw there the aggravating factors that are taken into account in death penalty sentencing in the state of Arizona. And in preparation for this presentation, I read through some of them, and they're basically some that you'd find in any state, but one of them is a bit unusual. I thought you might find interesting. But some of them are the murder for hire. We have that one. One that we don't have, I think, is that Texas has is if the judge is a victim of the killing. And I don't know that
maybe we should get that one.
We should probably get that. I don't know that we could get legislative support in the state of Arizona for that, but anyway. And then if the victim is under 15, if it's an unborn victim, and then if the victim is over 70. But the one of note that I wanted to call your attention to is number 14. So likely if they're ranked in order, or at least they were placed in order, this is the last of them. And it's the defendant used a remote stun gun or an authorized remote stun gun in the commission of the offense. Then it goes on with several paragraphs and sections to describe what an authorized remote stun gun is, the electrical discharge that is less than 100,000 volts, etc. So, it's probably something that came up in a killing that a legislator took upon themselves to add. But it's a bit unusual. I just thought in reading this that you might find that interesting.
So the new plan we put into place is really basic. We decided to assign all of the capital cases to 6 judges, and the presiding judge allowed me to handpick 6 of the criminal judges. 4 of them had extensive capital case experience. They'd either been prosecutors or defense lawyers before they came on the bench, and they had capital case experience. So I picked those 4, and then 2 didn't have any capital case experience, but I knew they were good case managers, and that's what I was looking for. So we consolidated all of them on these 6 calendars. They had 20, 22, 23 cases each. Every case was assigned a firm trial date, and that's what sent the county attorney and the defense bar over the edge. They said, you can't do this. You can't enforce that 18-month rule. I said, well, we're going to do it on all new cases. It's 18 months. You're going to get a firm trial date. All the cases that didn't have trial dates got trial dates. And then instead of each judge handling their motions to continue, all the motions to continue came to me. And I was pretty firm on enforcing the rule about continuances. If a case had been in the system for 30 months, 36 months, it was unlikely you were going to get a continuance unless you had a conflict with another case that we knew was going to go to trial. We also decided to do weekly meetings of all the capital case management judges. So every Tuesday, all the judges would meet in my jury room, and we go over a list of the cases that were pending and set for trial within the next few weeks, get the status. And it was great because we were talking to each other. I remember when I was a line trial judge, I'd get these capital attorneys in there. They'd say, well, we have this other case going. We need a continuance in the case that you have on your calendar. I said, okay. They go to the other judge with the other case and say, well, we need a continuance in that case because the case in front of Donahoe's going. So we were getting played. That didn't happen anymore once we started getting all the capital case judges together. And if you've got a diverse or widespread network of judges and you're handling with the same bar, I'd say, if you can't meet in person, maybe do weekly conference calls to talk, have all the judges talk, and get everybody on the same page. We want to do settlement conferences too, kind of unusual in capital cases, but we started to do settlement conferences where we bring in the victims, defense lawyers, the prosecutor, get everybody together to defend it and try to settle these cases, because we recognize that a lot of these cases were not capital. A lot of the victims didn't want their cases to be capital, and we were very successful in getting cases pled out to second-degree murder or even first-degree murder with the judge to decide the life sentence. In our state, we had natural life or life with the possibility of parole after 25 years, or if it was a child victim, after 35 years. So we were successful in doing that.
Can I ask you a question there? Of the 143, knowing your prosecutor, when you start with 143, how many of them really ended up capital murder cases at the end of that process?
The question is how many of those 143 actually ended up to be a capital case, going to trial as capital cases. We've got the statistics in the handout here, and I haven't summarized them, but it was probably less than 50% of those. And even fewer of those went to the jury with a finding of death. Some of them were hung juries in the sentencing phase. We had to retry them, but many of those were life sentences. So it was probably the ones that went to trial, it was maybe 50-50 on life or death. On all the new cases, as soon as I got the notice of death, I issued a scheduling order that set a firm trial date 18 months out from arraignment. So that was something new, that we put everybody on notice. This is when your case is going to go to trial, get it ready. We wanted to assure firm trial dates for these folks. So if the 6 judges couldn't try the case, it was assigned to them. We trained all our criminal judges. We had extensive capital case training. And if it came up for trial, one of the judges was in trial, I started calling around saying, can you take this capital case? And we did that. At one point in time, when we had this big bulge, we had 8 to 10, I think maybe even up to 12 cases, capital cases going at one time, because we wanted to show everybody that we were serious about getting through this backlog. And you can't imagine 12 capital cases or 10 capital cases going. We had 25 trial divisions. 36,000 other cases at the same time that we're trying to try. It was a resource issue for us too. This 136 cases represented less than 0.5% of our caseload, and we were devoting a third of our bench or more to these capital cases, and you'll see the cost to the county of all these capital cases. But that was the new plan that we did.
So then again, spring of 2009, in comes, at our request, BJA and American University, and their team quickly identifies some of the issues. You see here much acrimony among the stakeholders, those stakeholders being the courts, defense counsel, and there are 3 different, there's conflict counsel also, and the prosecution, mitigation specialists. 18-month timeline of the application of such, really it wasn't being followed very closely, certainly by the attorneys. The court then, some of the acrimony was that the court was trying to establish following the 18-month timeline. And the team management, when we looked at team management based on the resources that we had dedicated to capital case, and that especially the inventory, we only had the capacity here upwards to 70, to handle 70 cases. And so we had well over that number. And then we'll go in more as to the cost of litigation, but and you'll see some of these costs. Costs to manage and litigate capital cases, and this is in Maricopa County. 33% of all criminal department resources. You saw that half the resources, at least judicial resources, were dedicated, or a third of those resources were dedicated to that department, criminal. 33% of that, again, all was dedicated to those new 36 cases a year and upwards to 143 cases total. The indigent offense, as far as their costs, and this information comes out of the BJA American University study. That parenthetical 3 stands for the Public Defender's Office, Legal Defender, and Office of Conflict Counsel. So they all had separately teams that were mentioned earlier, and 26% of their budgets, indigent defense for Maricopa County, was dedicated to capital cases. And then you see $14.6 million of Maricopa County's budget as a whole was dedicated to those cases alone.
Yeah, we had to do something. With 140 cases, as you see on this next slide, a capital case can cost between $500,000 to $1 million to get through trial. 140 cases, that's $70 to $140 million that we didn't have in our county. So if we had tried to process all those cases as capital, it was going to bankrupt the county.
And I wanted to address costs, as I have here, and certainly since we're sitting and standing here in Maryland, I think this is interesting authority to go to. And we probably have attendees here from Maryland. Okay. So there, you see the website there, but this is a March 2008 study, so the study is fairly recent. So you see that these findings are a death notice adds $670,000 to these cases. And you see the trial phase of the case alone is 70%. And you see below those final bullets, capital eligible case with no notice filed is 1.1 million. That's for all of those. What makes up those numbers on the bottom right are the adjudication and the housing costs. So, just to call note on that last bullet, C, capital eligible case where death is, the sentence is death, $3.3 million. Of that, $1.7 million is for the adjudication process alone.
Anybody here from Florida? I just saw an article. They're going to impanel a jury for this Casey Anthony case. She's accused of killing her daughter. It's supposed to be an 8-week trial, sequestered jury. We haven't had a sequestered jury in Maricopa County probably in 50 years, but 8-week trial, sequestered jury. They're estimating just for the jury costs $350,000 for that case.
And here were some of the recommendations, again, that came out of the BJA study. Temporary application of case management requirement to cases in the inventory. So there was a discussion as to how we treat those cases that were already filed, that 143 or whatever the number was at the time of the issuance of the report, and moving prospectively, because there were certainly from the defense counsel, they believed that they had been in the process for some time, and some of these, as I said, were aged to 3+ years, and so they certainly couldn't be applied to that 18 months. And then again, there was some changes to the 18 months. I'm not sure where we are at this point with that timeline.
It's been extended now to 24 months.
Okay. And then again, any other questions at this point? Okay. Use of differentiated case management to treat these cases, serve as capital case judge for 3 to 5 years. There again, we wanted to train a cadre of judges to serve for a period of time to handle these cases, rather than have them spread out 15 judges of our 24 judges or whatever the number was handling these cases. So this was another recommendation from the BJA. And improve the use of application of discovery exchange between the parties. There were probably some game playing going on there. Institutionalize early judicial meetings with victims, and increase and improve the training and accounting. And then continue on the recommendations, use of early screening and ongoing case management by the judges. Those of us, again, who have gone through case management seminars understand the sooner a judge can get to have a case and manage the case, the better for the outcome and for the timelines and the reduced delay. County attorney should conduct review of death penalty notices. With the change in our county attorney over the years, probably even over the last maybe 5 or 6 years, we've seen at least 3 different changes in administration in that office. And at some point, our most recent past county attorney, it's not even clear whether he had a committee that was meeting to determine death penalties. It may have just been a committee of one, so to speak, determining the death penalty, whether the notice was to be filed. And then at the same time, we had problems with Sheriff Joe Arpaio and his team of delivering defendants to the courtroom, not necessarily the capital case, defendants, but all defendants at the time. And do you want to speak to that at all?
I ended up holding a contempt hearing and holding the sheriff in contempt of court. Of course, that's how dysfunctional this whole relationship was, because they were taking deputies assigned to transport and using them for the immigration sweeps, and so we weren't getting defendants to court on time. I ended up holding the sheriff in contempt, and he didn't like that. I don't want to go on a soapbox here, but this all led to a RICO charge, and then I was one of the RICO defendants because I was involved in this vast conspiracy against the county attorney and sheriff, and they charged me with 3 felonies about a week after they filed the RICO charge. So that's how dysfunctional this whole relationship was with the county attorney and the sheriff. That's the way it got. By the end of 2009, that's the state that Maricopa County was in.
Okay. No questions on that one.
Yeah, just Google my name and you'll see. There's a zillion newspaper articles about these criminal charges against me.
Yeah. And we have a new county, I'll tell you the state of things as they are now. We do have a new county attorney that was elected and took office in January of this year. And we still have the same sheriff, but everything seems to be on the mend, at least for now. So, and then not that this is maybe why things improved, but Judge, just as more background, Judge Donahoe is now assigned, because we do rotations, and we have merit selection for our judges, and we rotate judges. Presumptive term is typically 2 to 3 years. And so Judge Donahoe now is in our probate department. So you hear a lot of the acrimony and the strident relationships that were going on in criminal when he was there. Now it seems a lot of the focus seems to be in the probate department. The news media locally for us has picked up on some pretty ugly cases where attorneys are alleged to have charged exorbitant amounts of money in cases, and people have been treated well. So, moving on.
Yes, moving on.
The last couple of slides here, this shows some of the improvement in capital case resolution. So you see from January of 2010 to December of that same year, and then separated out by how the cases were resolved by jury or plea. Now again, the inventory continues regardless of who the prosecutor is. The average is about three cases a month that are new going into the inventory. So about 35 or 36 a year of new cases. Just as a note, in fiscal year 2010, again, that's from July of 2009 to June of 2010, we resolved 68 cases. So obviously that's how we took care of some of the backlog. 17 of those were tried and sentenced, and 40 of those through plea and sentence, and then through other means. And then lastly, the results of those resolutions, you can see that of those cases that were resolved from the previous slide, 10 of those received the death sentence, 30 life sentence, 13 less than life, and you can see at the bottom there, the other 12 were either dismissed, the notice was removed by the prosecutor's office, they were remanded, or the person was acquitted.
So I need two questions. Can you put that back up, that
Sure.
figure there? And this I don't get, all right, and maybe other people understand this, but why you now make it clear that you can get these cases moving, you put a lot of the burden back on where it belongs, on the prosecutors and others, and so they have to move them along and so forth. If I hadn't seen these last pieces and what you just said about they're still filing 3 of these cases a month, I would have thought the end of the story, maybe it's just me, would have been that they would have been much more selective about filing cases as capital death penalty cases. I would think that you still have a lot of outcome where they're not going to end up with what I thought the prosecutors would want, which is
Sure.
a death, a capital death sentence.
The question.
So why hasn't that really changed? I mean, why haven't those patterns changed? Does that make sense?
The question is, why hasn't the pattern or the rate of filing changed? That the prosecutor might become more selective. I think to a certain extent they have. We just had a spate of cases that you kind of knew they were going to go capital. They were either a law enforcement officer killing, child killing. You know those are going to go capital. And we just had some of those. I think the prosecutor is more selective. I think they do have a capital review committee within the office. And I think, unlike the other county attorney, he's listening more to what his committee tells him. The prior county attorney, the committee would say this is not a death penalty case, but he would tell them to file a notice of death on it anyway. But I think that if you, over the tenure of this county attorney, I suspect you're going to see fewer capital cases filed.
So it may just be too soon.
Right.
All this is going to have a lasting impact.
Right.
If we look 3 years down the road, when you get rid of all the ones that are kind of lingering from the past, you
Yeah.
get a real different pattern.
And you hit the point on the head, in that the system we put in place made the county attorney take responsibility and devote his resources to prosecuting these cases. Under the old system, with all the continuances, he didn't have to do that. But once we said firm trial date, that means for prosecutors too, you're going to trial, they had to reach out, they had to draft a lot of people in their office and devote a lot of resources to capital cases. It finally brought the decision to file all these capital cases back and made them take some responsibility for it.
Okay.
Good afternoon. My name is David Slayton, and I am a court administrator in Texas. And I want to tell you a little bit about some of the things that we've done in Texas to deal with our capital murder cases. Just to start off with a little story about how we began looking at this. Obviously, there are plenty of capital cases that occur in the state of Texas, as you'll see in a minute by the statistics. But you may not know that there are 254 different counties in the state of Texas, each who are responsible for, many of whom have a independently elected district attorney in their counties, and the counties are each responsible for the most part of providing indigent defense by the county, and there's very little state funding for it, to the degree that about a penny for every dollar, 10 cents for every dollar that's spent on indigent defense is provided by the state, and the rest is provided by the county. So one of the real issues that got me to looking at this and what we should do about it was a story about we have a county just to the east of us that one of our district judges covers. And the story came in that the prosecutor had to call, it was a heinous murder of a child just right over the border of the county. And the prosecutor had to call the family into his office. The family wanted the prosecutor to seek death, but the prosecutor was in the position of having to basically beg the victims to allow him not to seek death because the county couldn't afford it. And it would seem to be a tragedy to me that regardless of what you think about the death penalty, that should not be a reason for making that decision one way or the other. And so what we came up with was a system to try to help deal with all kinds of issues that we had, but that was one of the reasons that we had. Just to give you a little bit of background about the state of Texas, obviously a very large jurisdiction, geographically the largest state in the continental United States, just behind the state of Alaska, who is bigger geographically. We have just under 25 million people in the state. We have right at 3,500 elected and appointed judges statewide. And of those, 456 district judges, and in Texas, a judge equals a court. As opposed to having the Superior Court of Maricopa County, which has multiple judges, each judge in our state is a court. So dealing with silos is a lot of fun with us. So in our county, for instance, we have 6 district judges, and the reason why I'm focusing on district judges is they're the ones who have the jurisdiction to hear capital cases. The state statutes obviously authorize the death penalty with jury sentencing, and I've listed the aggravating factors here. These are the only factors that can be used to seek the death penalty and file a capital case in Texas. Capital punishment in Texas has been obviously in the news a lot. You've probably read about it. But in the 90s, in the state, we averaged just about 34 death sentences per year. Our highest year was in 1999 with 48 death sentences, and it's declined some since then. But since 2000, the state of Texas has executed 265 individuals, much more than any other state. Currently, there are 318 individuals sitting on death row awaiting what will happen to them. The one change that has made a big difference is previous to 2005, there were only 2 options for juries. It was death or life. And in the life jury instruction, we would instruct the jurors that life meant that the individual would be eligible for parole after 40 years. But then we would further instruct the jury that they couldn't take that into consideration when imposing the sentence. Always an interesting concept to me. I'm sure the juries didn't take that into consideration. But in 2005, the state changed the statutes to where the 2 options were death or life without parole. So those are the only 2 options in place. And since that time, we've averaged about 12 death sentences per year. The most recent year, we had 11 death sentences in the state of Texas in 2010. Just so you know, the state of Texas, for the most part, has not in the past at least had public defenders. Most of the counties in the state of Texas provide indigent defense through the delivery method of an ad hoc appointment system. And in fact, our largest largest county, Harris County, which contains Houston, which is the 3rd largest jurisdiction in the nation, just put a public defender in place this year. So it's the first one. There are now a few public defenders across the state, but still most public defense is provided through the ad hoc appointment system. And the way that works basically is the appointments are made from the private bar. Individuals who practice criminal law request to be on the appointment list, have qualifications to get onto that. They're screened and approved by the judges, and then they are randomly selected to be placed on cases. Same basic concept on a capital case. There are qualifications. They apply to be on a regional list. Each of the states divide into regions, as you'll see in a minute, and each region has a list that's approved, and that's where the lawyers get assigned from. The state of Texas also law assumes that if a capital case is filed, that it is a death penalty case. There is no requirement to file a notice of death. Instead, it's the other way around. It's assumed death until the prosecutor files a waiver of death. So because of that, from the day the case is filed, it's treated in our courts as a death penalty case, and of course all the resources begin pouring into that immediately. One thing that's interesting is there's also no rule or statute that requires the prosecutors, there's no timeline on when they have to file that waiver of death. So it may be that they file the waiver of death the first day the case is filed, or it may be that it takes them 5 years to file the waiver of death, and there's no requirement that they do that. So obviously from the court side of things, that's complicated and causes us to have to take measures to deal with that. In addition, the state requires that we appoint 2 lawyers to all death penalty cases. And of course, since there's an assumption that each case is a death penalty case, we have to appoint 2 lawyers from the time the case begins. We also, because of Supreme Court case law, have to appoint mitigation specialists or experts and investigators to all these cases, so you can see the cost that keeps coming with that and the issues that arise. Some of the results that we were finding back in 2007 when we began to look at this is that because of the ad hoc system, we had very few counsel who wanted to do this job. Obviously, if you talk to the lawyers who do this, it's a very difficult practice. And in our region, there were so few cases that no one made their full practice in doing this. So, for instance, Lubbock County is the largest county. We average about 2.5 capital murder cases per year. That's not enough for anyone to make a practice out of, and so they would do it as they came up, the cases came up, but they had to do family law and other criminal law and other civil law cases and things like that. And so when they got assigned to a capital case, they basically had to shut down their entire practice, basically bankrupting themselves. So it was a real difficult thing for them to do, and all the lawyers that we talked to who were on our list stated that they had no desire to keep doing it. They were just doing it because of public service. They felt like someone has to represent the defendant, so it might as well be them. A second issue we were having was because of all the various factors I've just described, most of these cases were, the time from filing to disposition was at least 2 to 3 years, and that's probably being optimistic. Many cases in the region would last for 4, 5, 6 years from time to disposition, and our goal was to have them also disposed of in 18 months as well. I'm not sure that before we changed our system up, we had any cases disposed of in 18 months. The issue of cost became a big factor for our county and our courts. In the state, in the region where we're at, depends on the size of the county, how remote it is, and things like that, but it's estimated that the cost of indigent defense for a capital case, just for the defense piece, is between $250,000 and $1 million per case. And that doesn't include the cost for appeal, cost of the transcript, other experts that may be necessary, and things like that. So if you're looking at, a county that, for instance, we have a county in West Texas who has 67 individuals. That's the population. The joke is there are more cows than there are people who live there. But you can imagine if there was $1 million indigent defense bill dropped off, divide $1 million by 67, and it's not a pretty picture for that county. So you can see where those issues came up about we can't afford to do this easily there. Even for the counties who had the finances to do this, the budget unpredictability was a real issue. It was uncertain every year if you were going to have a case or not. So do we budget this year for a capital murder case or not? Of course, we don't know what's going to happen. So every year was just a kind of a guesswork. There were very few counties who budgeted for this because you didn't know, especially the more rural counties, had no idea when a case might come up and when it wouldn't. And the last issue that we had were because of the fact that defense counsel were distracted by other cases and had other issues going on, then there were oftentimes error. And then, as the picture shows, the burning of the money, we ended up trying these cases 2, 3 times, and obviously those costs just double and triple when you have to do it 2 or 3 times. So that was where we were at in 2007, and we really felt like we needed to try to address the issue. So what we tried to do is come up with a regional solution. Obviously, it didn't make sense to us to try to establish a public defender to handle just capital murder cases for 2.5 cases a year in Lubbock. It wouldn't have made sense. We couldn't have staffed that. But what we decided to do was what a lot of things happen in Texas is to look at regionalizing this approach. So the state is divided into 9 administrative judicial regions, and they're listed here. Lubbock County is just in the very south of the 9th region. And if you look at the West Texas region, the 7th and 9th region consist of 85 of Texas's 254 counties. And so the 7th and 9th administrative judicial regions got together and decided to form a regional capital public defender who would handle their average of 25 cases per year in the region. And I will tell you, just give you a little bit information. We have since this year have expanded that to cover that office to cover the 4th, 5th, and 6th administrative judicial regions. The anticipation is that, absent some budgetary crisis, we expect to expand that to the 2nd and 3rd judicial regions in FY 2012, starting in October, and then the last 2 regions, the 1st and the 8th region, the next fiscal year, so that every county in the state of Texas will be covered by this capital public defender, except for the most urban areas. They're excluded because they have the defense mechanism in place. So that's 14 of our counties will not be in this at this time. So what we basically have done is staff the offices to handle all the cases, and it includes attorneys, mitigators, investigators, legal staff, things like that. And counties can opt into it, so they don't have to do this if they don't want to, or they can participate if they want to. And the way it's funded is through a cost allocation method. We look at both the average or the actual population of their county and the percentage of their population of the whole, and we look at the number of cases that they have as an average and a percentage of the whole. So we didn't want to do one or the other because we have some counties whose populations are low, whose prosecutors' charging practices cause them to charge more cases as capital murder than maybe other counties who are larger than them do. But at the same time, obviously, so we tried to take the two-sided factor here into note here. So that's basically how the office is funded. And now, currently, with those 5 regions that are currently in place, the office covers about 2.6 million people, 149,000 square miles. We do have 5 offices. As you can imagine, that's a long way to drive. And it's obviously in the western side of Texas is very remote. We have 5 offices there. We have 98 district judges who are in that region, so that's how many judges are presiding over these cases. 68 different elected prosecutors that the office gets to deal with, and currently a staff of 22, and you see the breakdown there through attorneys and mitigators. Basically, we have staffed it to be a 1-to-5 ratio. For every one lawyer can handle 5 cases is how it's currently staffed. So you can see the office is currently staffed to handle about 50 cases a year. One of the most interesting things that has just come out, and our plan for this next year is to form, as part of this program, a Office of Conflicts Counsel, so that the public defender can handle the first case, but the conflict counsel will be able to handle the second case. So each county will have access, that joins will have access for the same price. We'll have access to both for 2 defendants if that was necessary. So just kind of giving you the results here, the office has handled to date 31 cases. They went to trial on 1 case. And you might say, well, what are they doing? For them, that's a win. Jack, who Carolyn was talking about, Jack, who's the chief public defender, was stuck in Lubbock in snow. He would tell you that a trial is not where they want to be in these types of cases, because in at least our region of the state, if it goes to trial, most of the time it ends up being a death penalty sentence. So for them, a trial is not always a good thing. And if they can work it out in some other fashion, that's what they'd prefer to do. Just to give you a sense of how long these cases were pending, even the case that went to trial was only pending 16 months, obviously much shorter than what we had before. As guilty pleas have averaged about 10.8 months in length from time of filing to disposition. The cases where the DA's office has waived death have averaged just over 10 months. And they currently have 7 cases pending, and one of them has been pending for 21 months, and it's set for trial in May. So those are basically kind of the results so far. Just as a quick little story here, one of the cases that they resolved is actually kind of interesting. An individual who they had a case on, it was a heinous crime, killed a baby, and he was what Jack would refer to as a volunteer. An individual who wanted to be executed and would not take any plea deal because he wanted the jury to sentence him to death and wanted to be executed. And as part of the process, some of the team members that they bring into this, one of the ladies that has been helping from Texas Tech University is a English professor, a creative writing professor. And you might wonder what in the world an office like this would need a creative writer for. But something I've learned is that the defense wants to take the mitigation information and present it to the DA's office, and they want it to be a compelling story for the DA so that the DA will reconsider seeking death. And so they use this individual to help write the story creatively so it's more compelling. And so this lady was interviewing the defendant who wanted to be the volunteer, and saw on his cell where he had drawn all these different pictures, and they were amazing drawings. And she was publishing a book, and she asked him to publish, to let her purchase from him a picture to put on the cover of her book. And this individual who had never been seen himself as anything, certainly all of a sudden had a purpose in life, and decided that he would not be a volunteer for execution. And so they published the book with his picture on the cover. There's an interesting little story where they presented him with a copy of the book and a $50 check. And interestingly enough, as part of the plea deal, he wanted new teeth. So they got the county to buy him new dentures, and he's now sitting life without parole in prison, but took the plea deal and saved the county from having to go to trial on this case and lots of money. So it's just an interesting story of a certain case that they had. Some of the factors, and this is specifically Jack's piece of the presentation, but some of the things that from the defense side that are important are that they have a team approach. I mentioned to you a number of the team members, the mitigators, attorneys. They've brought in all kinds of volunteers from Texas Tech University School of Law. They have a capital clinic now where students are volunteering to come and work with the office. And, of course, as I mentioned, the English professor. So they work together as a team. Instead of it the way it used to be where an attorney would be out on his own or her own trying to figure out how to deal with this case and what the strategies should be. Now they have all 10 of these attorneys coming together, talking, all the other staff contributing, and obviously when there's that many people in the room, the ideas can be more creative. They also work on consistent protocols. For instance, one of the things that they do is they immediately get working on the case from the moment that they get assigned the case. Obviously, in these types of cases, time is of the essence, and so their policy is that if they're appointed on a case, that they'll make contact to the defendant within 24 hours of appointment. You can imagine that some offices are 300 or 400 miles from the jail where the individual is being held. So typically when they get the appointment, someone is in the car in probably 15 to 20 minutes headed to a jail somewhere and says, here, send me an email with the guy's information in it and I'll visit with him when I get there. But those types of things are protocols. They also make sure to have frequent contact with the defendant as they go along. As you probably know, in other indigent defense matters, defendants oftentimes get really upset when they're not seeing their attorney often enough. And in a capital case, earning that trust of the client is really key to the defense strategy. And so they try to make contact at least with the defendant every 2 weeks, even if they don't have anything to communicate with them. Just go see them. So that's an important protocol that they go off of. As I mentioned, they get together and have team meetings, and they have weekly staffings on these cases. So each attorney and mitigator and investigator bring their cases to the staffing, and they talk about them on a weekly basis so that they're helping work together through the problems that they might be experiencing. And through these team meetings and the team they obviously have an interdisciplinary approach. Previously, whenever there was a case assigned, the attorney would be assigned, the mitigator would be doing his work somewhere, the investigator would be doing his work or her work somewhere, and they weren't really communicating and working together as much. And, of course, now with it all in one office, that work is occurring as a group. So those are basically the factors that have helped move these cases along. And, the courts obviously are involved in this to a certain degree, but the thing that we really needed the most were lawyers who were dedicated to handling it. And now I'm going to pass it over to Kathy for the rest of the presentation.
Okay, so what I'm going to talk about is specifically the appeals process and how case management of these capital cases affects the appeals process. When I was asked if I would be interested in participating on this panel, I jumped at the chance because I oversee the Los Angeles Superior Court Appeals Unit. And we have a lot of capital cases, and we have a lot of death penalty sentences every year, so we have quite a large volume of appeals. What I started doing initially was I started researching the appeals process for the other 34 states that also have capital cases. And what I discovered real quickly is that everybody has a completely different process for their appeals. However, hopefully somehow we can all, you'll find something in this presentation that has to do with your state, wherever you are. Los Angeles County and the Los Angeles Superior Court, we have a population of 10 million in Los Angeles County. We have 48 courthouse locations, so 48 separate courthouses within the county itself. We have 600, a little more than 600 bench officers, and our annual felony filings last year were 60,000. LA County is among the nation's leaders in ordering executions, and I'm not sure if that's something that we should be proud of, but we are. You can see in 2009 we had 13 death penalty sentences. The state of California in total had 29. The state of Texas had 11, and Florida had 14. In 2010, I know that we had 10 death penalty sentences in Los Angeles County alone also. I didn't have the numbers for the other states, so I didn't want to put in the 2010 statistics. And we have kind of our prosecuting agency is the district attorney's office, and they have something similar to what Maricopa County has. Is they have a team of death penalty prosecutors that meet on a regular basis. They have a team of district attorneys that meet once a month, and they go over all the cases that are eligible for the death penalty. Just because a case is eligible for the death penalty doesn't necessarily mean that the prosecutor is going to be seeking the death penalty on that case. They will file the case, and it is capital eligible. However, it may go, I think like Texas, 2 or 3 years. Well, we're opposite of Texas. We may go 2 or 3 years in a pretrial status before the district attorney actually declares, yes, we will be seeking the death penalty. And the reason I believe our county does that is because the prosecuting agency wants to get through the pretrial and the preliminary hearing stages of the case prior to actually declaring we want to seek the death penalty. That way they, I think, get a feel of how strong their case is. So generally we run about 50 to 55 cases, what we call our pending caseload of capital cases. And I receive a list monthly from our prosecuting agency's office, and here's just a copy of what the list looks like, and it gives all the litigants' information, the courthouse location, what department is hearing the case, and when the decision to seek the death penalty was made by the prosecuting agency. And the status would be the next hearing date. And it's divided up by the prosecuting agency's branch areas. Similar to Maricopa, we have a group of probably 6 or 7 judges that this is their specialty. These judges are in trial constantly on death penalty cases. And as you know, some cases can take 2 months to get through the trial phase, so they may only do 2 or 3 jury trials a year, but they're constantly doing these capital cases back to back. What I do as the administrator of the appeals unit is I receive this list, and I'm looking at this list to see, and here's page 2 of the list, to see any new cases that pop up on the list. And there's one right here in the middle. In January of 2011, the district attorney declared they're going to be seeking the death penalty on the James Fayad case. What I want to do is I want to keep track of the cases on this list so I can see what's in trial, where we're about ready to get a possible verdict of a death penalty. Because it starts an immediate appeals process. For state of California, there is no requirement to file a notice of appeal. It's a direct appeal. So time is very important to our unit to make sure we get the case the day the sentence is imposed. We also, in California, we have a 2-stage certification process. Pursuant to our rules of court, once prosecution notifies the court that it intends to seek the death penalty, the judge orders the record of the preliminary proceedings to be prepared and certified as accurate and complete within 120 days. So what that means is the judge has to order the court reporter to prepare a transcript of all the proceedings that had taken place up to the date that the prosecuting agency is declaring they're seeking the death penalty. That may be 2 or 3 years worth of pretrial or preliminary proceedings. What we're trying to do is we're trying to get a jump start on the record, get that beginning process of the record prepared so that the parties can look it over and make sure that the record is accurate and correct. Because now the DA is declaring they're seeking the death penalty, it kind of jumps it into a whole nother status, and it goes into a whole nother set of pretrial phases. What that may take another year or 2 or 3 years on its own. So we want to get the first part of the record prepared, and it is a rule of court for us in California. Also, when the prosecuting agency lets the court know they will be seeking the death penalty, the judge from that day on orders the court reporter to prepare a daily transcript, an original and 2 copies. And the next time the court reporter comes back into the courtroom on that case, she provides a copy of the transcript of the last proceeding to counsel and to the court. Counsel is supposed to look over the transcript and make sure that there aren't any errors in the transcript. They're also supposed to be reviewing the court file on a regular basis, including all the minute orders for accuracy and omissions. Then once sentence is imposed, and you know, in our county we do have such a large volume of these cases, it may go 2 or 3 years in the pretrial jury trial stage before the jury trial actually finishes and the sentence is imposed. Once sentence is imposed, the day it's imposed, the court clerk, my office, has to send a notice to the reporter to prepare a transcript of the entire proceeding. In most instances, that is 4 or 5 or 6 years worth of proceedings. So you can see why, if we have ordered the reporter to prepare daily transcripts along the way and asked counsel to review those transcripts along the way, it certainly helps speed up the process. At this stage, the court reporter should be able to just hit print on the computer and print up a nice clean transcript. That's if everybody has been reviewing it and doing their job. Doesn't always happen. The clerk prepares an original and 8 copies of the clerk's transcript. You know, I don't know, most of you may or may not know that an appeal record generally consists of 2 parts: a clerk's transcript, which is all documents contained inside the court file, the jury instructions, the juror questionnaires, and in our county, at least, death penalty cases, we can have, you know, they may call in 500 jurors. You know, if they're high-profile cases, that's a lot of juror questionnaires. And the reporter's transcript is the second part of the record on appeal. So what we have here is a record. This is a clerk's transcript for an appeal record that I took 2 or 3 days ago. This is one of our current pending appeals. The California Rules of Court dictate how we put together the record. Each volume of a transcript can contain no more than 300 pages. It must be paginated consecutively. It must have an alphabetical and a chronological index. It must have a cover sheet with all the players' names on it. This clerk's transcript is 96 volumes. That's just the documents contained inside the court file, the jury instructions, probably 4 or 5 years worth of court file. You can imagine the fun job it is to put this all together in chronological order and to paginate it. That in itself is a full-time job that takes quite a long time. Now imagine if there are documents missing from the court file because it's been running around, you know, the county for 3 or 4 or 5 years in different courtrooms, and different attorneys have appeared on the matter, and you know, one attorney comes in and they want to look at the file because they heard one of the other attorneys filed a motion 4 years ago, and can I take a look at that motion? And then the motion disappears from the file. My office, the appeals office, is responsible for obtaining all the documents that match the minute orders, and that's assuming all the minute orders are accurate. That's a whole nother, you know, issue. That the documents and the minute orders match up, and they go in chronological order. And then, like I said, it gets paginated. We get 30 days to do this, 30 days from the date that the judgment is imposed. So it can be a very frustrating job if a case has been traveling around through the system, pretrial and jury trial phase, for 4 or 5 years, just because a court doesn't want to go to trial on the case. We do a very good job in LA County. We do have judges that are constantly in trial on death penalty cases, but you can see why it's very important that the management of these cases be taken seriously as far as the appeal record is concerned. Areas of concern for appeal records when case management practices have not been implemented, court clerk duties and responsibilities are not followed. What that means is, simple things. Minute orders are not filled out accurately or correctly. I can't tell you, believe it or not, how many times a clerk will list the wrong reporter on the minute order because they got a new reporter in that day and they forgot to change the computer system that showed them, the court reporter that usually sits in that courtroom. So when we do the notice to the court reporter, that court reporter comes back and says, I wasn't in your courtroom that day. I don't know what you're talking about. Documents are missing from the file. Like I said earlier, people come in and they look through those files, especially counsel, and they take something out of the file with good intentions. They're going to go take it, make a copy of it, and then they get sidetracked and forget to put it in the file. Minute orders do not match the documents in the file. Judges, counsel, reporters move, retire, or pass away. It's not uncommon at all for us to try to find a court reporter or an attorney or a judge that heard the case in a preliminary stage, and now they are retired and they live in Florida or they live in Hawaii. They have no vested interest in the case at this point. So when we're trying to get them to help us produce the transcript, it's not an easy thing. Trying to contact the players that no longer reside in the area. In California, counsel has 30 days to review that record and request correction hearings. So that 96 volumes of record gets mailed out to counsel along with a little declaration that tells them they have 30 days to review that record and to declare whether it's accurate or there are changes that need to be made. That doesn't happen very often. Usually they're asking for extensions. Steps we take to ensure proper case management of the appeal record. I have a staff of one court manager and 5 full-time clerical personnel. All they do is work on death penalty cases, death penalty appeals. The court manager appears at all the record certification hearings so that they can be on top of the game. If there's corrections that need to be made to the record, the court manager is aware of it, and she will go back to her office and she will call the court reporter herself and say, Madam Court Reporter, the judge ordered this in the case today. Can you get started on that today? Declarations filed by attorneys for corrections to the record are provided to the manager for coordination with the trial court, court reporter, Supreme Court, and all counsel. In California, we have rules that govern record preparation, as they do in all states. And in our state, it's a 2-stage certification process. They review that large transcript, and that's called the certification for completeness stage. The judge must certify the record is complete within 90 days, so that includes counsel's 30-day review, declaring any changes that need to be made, and then filing a declaration that the changes have been made. We then notify the Supreme Court that the record is complete. And then we sit on it. We hold that case, we hold that record until appellate counsel has been appointed. And like everybody else, our state has real problems getting appellate counsel. Who wants to be an appellate counsel on a death penalty case? It's not a pretty thing. And this is after they've already been found guilty and sentenced to death. Now they get the fun job of reviewing that record and trying to find a reason or an error in the record somewhere. Usually it takes about 5 to 7 years in California for appellate counsel to get appointed. Once they are appointed, the Supreme Court notifies my office. We send out a copy of that record, a copy of that 96-volume transcript to the appellate counsel, who gets to review the record again. That's called the certification for accuracy phase. They review the record and they notify the court if there are any errors in the record or any omissions. They're going through it with a fine-tooth comb. They're looking for any reason to sink their teeth into to have an issue for an appeal. So they do go through it very thoroughly. Once everybody has determined that the record is accurate, the court certifies the record. The trial court certifies the record finally, probably 7 years after the judgment has been imposed. Then we make 9 copies of that 96 volume record. We make 9 copies. Supreme Court, Defendants Appellate Council, Habeas Corpus Council, Attorney General, Habeas Corpus Resource Center, California Appellate Project, Governor's Office, Trial Counsel, and the District Attorney all receive a copy of that record. There are institutional arrangements and resources that have a direct effect on the record on appeal. All states have rules for addressing appeals to the state court of last resort, and variation in these rules affect case processing time. Some states have enacted laws or court rules intended to speed up the process and increase efficiency in capital appeals processing. What I did find in my research is that a lot of courts, a lot of states, Nevada, for example, and I think it's on the next slide. No, Nevada, for example, says that their appeal has to be ruled on, the decision has to be made within 150 days of the Supreme Court receiving the record. That's a pretty tight timeline on a capital case. But that 150 days starts once that Supreme Court receives the record. The problem is getting that record together, getting an accurate record together, so that the Appeals Council and the Supreme Court can review the record without having to say, you know, where's counsel's motion that was filed in 2002? It's not contained in the record. The rules ensuring that the trial court record in capital appeals is transcribed in a timely fashion, and those are, we have those rules in California. Rules giving preference to capital appeals. In most Supreme Courts, capital appeals get put to the top of the docket. Rules requiring that decisions in capital appeals be reached within a stated time period. And here's, like I said, the Nevada Supreme Court. They have some strict guidelines and timelines. And most Supreme Courts have, they will issue sanctions to the trial court. At least they do in our state. LA County, we've been chastised by our Supreme Court in the past for not getting records to them in time. And so the impact of delay in capital case process. This is kind of a summary of the capital case process in itself. You know, it decreases the finality and administration of justice, decreases public confidence in the system. You know, I'm sure all of your states are like our state. You know, the media is all over it. How long does it take to get somebody? You know, California, we have 637 people sitting on death row. That's a lot of inmates, and you know, whether you're for the death penalty or against the death penalty, something isn't right. You know, it costs so much money for these people to sit there. The emotional trauma on the families. How many, you know, the victims' families, the defendants' families. It's traumatic for everybody involved. There's an increased cost for maintaining inmates. I think somebody said earlier that an inmate sitting on death row doesn't get the same. It costs them twice as much as it does for a regular inmate that's just sitting in state prison life without parole. And it creates a basis for additional litigation. If it takes 5 years through pretrial status to get a case to trial, well, every time that case appears on calendar, it's opening up some issue that might be an error later on down the line, and additional litigation comes out of that. So I think, you want to summarize? Or?
We're pretty much out of time, but I can accept any questions. Anybody have any questions?
I think I've got one.
Yeah, John.
When you present all this information to your county budget office or your state of Texas or your region, or is this compelling information to them to recognize the scope of the issues that face you and the need for resources and so forth? Or, I mean, with the absence of this information, I suppose we got nothing. But with the information, as you found, it made a difference in Texas or in California when you lay all this out?
The question is, with all this information that we have about the cost and the factors about whether that's made a difference in the budgeting process, legislators, and all those realizing that. I think it has. Interestingly enough, I don't think that a number of policymakers across the state, whether that be at the county level or at the state level, realize the cost of what capital litigation really costs until we start talking about it. We do have some counties in the state, in our region, that are eligible to join who will not join because, it's just too expensive to pay that $1,300 a year to be a part of this office. The cost to be a part of the office ranges from a minimum of $1,000 to a maximum. The largest county currently pays $140,000. I showed you that one case generally averages $250,000 to $1 million. So obviously it's a financial deal. It's being referred to as murder insurance across the state. But some counties still don't get it. But the majority of the counties, when they start seeing this information, and the state policymakers are saying, yeah, this is very expensive, and we've got to figure out a better way to do this. We've actually gotten a lot of notoriety across the state from the state legislative body, saying, this is a great program, and we really should be, figuring out how to take this to scale. And that's the reason why we do have a lot of grants that are helping us expand the program out across the state.
And I know from Maricopa's standpoint, the budget for indigent defense and for the prosecutor's office is paid through county funding. And so they're acutely aware of what they do spend every year, and you saw some of that in earlier slides for both of those budget centers. But they can and do have a little bit more control over the public defender's costs in that it's not an elected official. It's an appointed authority in our county. The prosecutor, however, as we heard through our presentation about Maricopa County, is an elected official and controls when a death notice would get filed. And with that, we conclude. We, as a representative of the panel, I certainly appreciate your attendance, and I thank you all. Thank you.